Okay, we're going to get started again. Somebody, I can hear that maybe you're eating while you're on your mic. So make sure you're muted until you want to speak. Thank you. Go ahead, Camille.
Okay. It's 1 o'clock and we're resuming the September 18th meeting of the San Juan County Planning Commission. And next on our agenda today is land use and rural policy issue briefings and vacation rentals. Is that you, Adam?
That's me.
Yeah, I guess we can just check and see if the commissioners have all returned. So I think I heard Tim. David, are you back?
Yep, I'm here.
Okay, Mike is out for the rest of the day. Dale Roundy.
I'm here.
And Steve Rudy.
I'm here.
Okay, so we have a quorum, but we don't need a quorum because these are briefings. And Adam, you can begin, please.
Okay, thank you. And thanks for the lunch break. That was much needed. We're going to go here. So next we'll take a look at the vacation rental issues that have come up. So vacation rentals are either a single family residence or an accessory dwelling unit or ADU that is rented for less than 30 days. So it's very specifically defined in our code as that. So other things are other things. Our land use policy in the existing land use element states that a vacation rental is a residential use that should be regulated like a hospitality commercial establishments. So subject to the same kinds of standards that we would apply to things like bed and breakfast and hotels. The result of this policy is that many of our regulations in the code regulate things like number of guests and some of the other noise impacts that may come from vacation rentals. Some of the issues that have come up during our comp plan update and in public comments are that many folks are concerned that vacation rentals contribute to our affordable housing shortage because they occupy dwelling units that could be affordable long-term rentals. Another concern is that the impact of vacation rentals, that vacation rentals have a negative impact on neighboring property owners. We hear a lot about trespassing, noise, and parking concerns when neighboring properties are operating a vacation rental. On the other hand, the majority of our visitor accommodations in the county are provided in vacation rentals, and tourism is a major part of our economy here in the islands. So changing those vacation rental regulations could also impact that sector of the economy. So it's important to keep that in mind as we're debating these issues. Looking at, this is a map here of vacation rental permits throughout the islands. These are compliant vacation rental permits. The green dots are active permits and the tan dots are inactive. We have 632 compliant permits as of April of this year. 430 of those are active, meaning that they're currently being rented out or listed. And then 202 of those are inactive, meaning that the owners are not renting them out or listing them at this time. The permits are more concentrated in areas with smaller lots. If we look around the countywide average of lots with vacation rental permits is about 3.3 acres. And in many of the areas with the highest density of permits, the average lot size was closer to 1 acre or less. So in places like the UGAs and some of the older neighborhoods that were platted before we had the minimum densities that we have now, they're on those much smaller lots. East Sound specifically, the average vacation rental lot size was 0.6 acres, so just a little more than half an acre. And looking countywide, about the 632 compliant permits is about 4.5% of our 14,000 housing units countywide. Our vacation rental regulations are established in San Juan County Code 1840-275. The regulations were adopted in 2018 and include additional enforcement measures that allow us to take a look at the listing, and if they're not listing their permit number in their vacation rental listing, they could be subject to code enforcement. Some of the other key regulations are that outside of our urban growth areas, only one vacation rental permit is allowed per property. And then vacation rentals are not allowed in ADU permitted after 2007. Again, that's outside of the urban growth areas. And then also anywhere in the county, the number of guests is limited to 2 per bedroom, plus an additional 3 people. So in a 2-bedroom house, that would mean that the number of guests is limited to 7. Additionally, we require that operators have rules of conduct to address the potential impacts to neighbors. So these would be like clearly defining where the property boundaries are so that people aren't trespassing inadvertently, having quiet hours and those kinds of things in their rules of conduct. And then also one of the major changes that we made with the vacation rental regulations is that they must annually certify their compliance with their permit conditions. So all operators have to submit a form to the county every year that says that they will comply with the requirements of their permit. And then finally, vacation rentals, as I mentioned earlier, they cannot be advertised without an active permit, and they have to include that permit number in their advertisements. This has really helped us go find unpermitted vacation rentals, and it gives us a mechanism to address that that didn't exist before these regulations were updated. So they really help to increase our enforcement and kind of figure out who's actually operating by active and inactive permits. We've had 2 issues come up, kind of broad issues that have come up around vacation rentals. I'm sure you're very familiar. You've heard your neighbors talking about these kinds of issues. One is limiting the number of vacation rentals allowed, and we'll look at a couple of different options of how we can address that. And then we'll take a look at vacation rentals in the urban growth areas and whether or not they should be limited there to address the issues of concentration of vacation rentals, particularly in these really dense areas in the county. So the current vacation rental regulations do not limit the number of vacation rental permits, either annually or in total. So as I mentioned earlier, as of April 30th of this year, there were 963 permitted vacation rentals, but of those, only 632 have submitted certificates of compliance or are in compliance. Of those, 430 are active and 202 are inactive. Many public comments have suggested possibly setting a limit to the number of vacation rentals, and we can look at whether we want to limit the total number or look at them annually. Some of the general benefits of setting a limit are that we would have the number of homes used for vacation rentals would be limited, and so that might make more homes available for permanent housing. Fewer vacation rentals might increase demand for alternative accommodations in commercial areas, such as like resorts or hotels, and it might shift some of that visitor population back to those kind of more traditional accommodation types. And that would also, by kind of shifting those to commercial areas, that might reduce some of the conflicts with surrounding residential uses, particularly in those outlying rural areas. Some of the drawbacks of setting a limit is that this could reduce the total supply of visitor accommodations. As I mentioned at the start, one of the one of the vacation rentals are one of the most prevalent types of visitor accommodations in the county, and we would be basically reducing that supply. It could increase the cost of housing kind of at large, as existing residences with a permit would have more value if we were capping it. And it could possibly slow the growth as a result of kind of limiting how many people or how many places people can stay when they come here for tourism. There are a number of ways that we can consider setting a limit on vacation rentals. The first option that we looked at in the staff report is to limit the number of new permits allowed each year. The cap could be set as a percentage of new construction or as a flat rate, such as like 30 per year or 25 per year. And we could allocate the limited new permits through a lottery drawing, very similar to how we do accessory dwelling unit permits currently. And so option A would cap the total number of permits allowed, option A would not cap the total number of permits allowed, but it would limit the growth of vacation rentals as a share of our housing stock. So it wouldn't necessarily establish how many total we could have, but it would slow the rate of growth. Option B would limit the total number of vacation rental permits to the number currently permitted. This would effectively limit the total number of vacation rental permits because we would basically say that we are not going to allow any new or any more than we currently have. As permits became available because permits were abandoned or revoked, we could allocate those new permits through a lottery system, similar to how we do the ADUs. And then the number of permits that would become available in this way, though, would probably be fairly small because permits are rarely abandoned or revoked. It's not a common thing for people to just kind of walk away from these things. But this option would make it very hard for property owners that do not have a vacation rental permit to get a new permit. Option C is very similar to option B, but we could set a per island limit to vacation rental permits. So we could say on San Juan, Orcas, and Lopez, only X number of permits are allowed. Then finally, option D would establish a minimum lot size for vacation rental permits. And this could effectively limit the number of vacation rental permits by disqualifying smaller lots from getting new vacation rental permits. A minimum lot size would have the added benefit of reducing noise and trespassing and parking impacts to the neighboring property owners, because it would really limit those vacation rentals to larger lots where homes are spaced farther apart. And then finally, option E would not make a change to the to establish the limit of vacation rental permits. We're not necessarily required to do this, but not making a change here would probably be fairly unpopular. So those are the options that we came up with for this issue in particular. Since there's kind of a lot of different approaches, we thought it would be best for the Planning Commission to kind of mull this over a little bit without a staff recommendation. So I'll open it up to discussion here.
Hey, Adam, David Kane here.
Go ahead, David.
Oh, hey. So, Adam, looking at slide 46, that had the issue 1 on it, it talked about 963 permitted and 632 that are compliant. So what about the 331 that are permitted but not compliant? Can you tell us about those?
Yes. So those are going to be subject to a code enforcement, and Erica might be able to speak to the process that we'll be using for that a little bit more. But essentially, we need to, if they are not going to submit a certificate of compliance, they could be revoked. And we're going to work through that process here pretty soon. I don't know if Erica wants to talk about that a little But,
So this is Erica. The process for the ones that are not in compliance, there are two types that are not in compliance. There are those that sent us a compliance certificate in either 2018 but didn't in 2019, and then and they're a different subset. We think that probably most of those are inactive, and we didn't send a reminder out last year, so we think that they just probably thought they'd done it once and that was all they needed to do. So they'll get a reminder that they're out of compliance, like our warning letter, and that if they don't give us one for 2019, then they will then we'll start the process to revoke their permits. We have about 170 of them who have not given us a certificate of compliance in either year. And so they are completely out of compliance. We will be starting the process to revoke their permits. Only the new permits are the ones that are subject to just expiring. So all the old permits, we have to go through a process, and they have to be we have to hold a hearing in order to revoke their permit. We will, of course, do what we can to get some folks to voluntarily just abandon their permits versus go to hearing for their permit to be revoked. But it's a big job. I think I figured out the amount of hours it would take is it's like 2 people for a year to go through hearings and staff reports and everything for 170 permits. So it's a big job. But like I said, we will attempt to try and get people to voluntarily just abandon those permits that are not compliant.
Correct.
Could I ask a question? Could I ask a question right here, just so we capture the data while we're talking about it? Old permits and new permits. Erica, can you tell us how many fall into which category?
Not off the top of my head, I can't. There may be 100 are the new permits that we've permitted since we changed the rules, and everything else is old and has to have a permit reviewed. So in 2018, when we changed the regulations, everything that came in after, say, March of 2018, when those regulations went into effect, are new permits that if they don't comply will just expire. But there's only probably 100 of those. I could go back and check, but that's about how many we would have approved in the 2 years.
And the permits go with the property, not with the property owner?
That is correct. You could make a rule that says that it only goes with the owner of the property instead of going with the property. But again, the real issue is how you apply that to the older permits in the past. It becomes a really expensive legal problem to apply those rules to regulation in the past.
Well, can I clarify something there? It was my understanding that maybe this is not correct, but that old permit category had a couple of types of permits in it: those that ran with the land, and those that didn't, but were just continuous. Is that not correct?
You are correct. And when we go through and look at the old permits for compliance, it could be that we find multiple that don't. Some of the conditional use permits, and not every permit, got conditioned that they were only valid for the applicant. But it was a very case-by-case basis.
Okay. I mean, the reason those numbers make a difference is, to me, and in my way of thinking about it, is sort of a fundamental fairness question. If we're talking about a lottery system under a cap, because if the vast majority of permits are going to be grandfathered, that introduces its own kind of unfairness in terms of use of the land. But okay, I was just curious about the numbers, because I know the ones that run with the land are going to be problematic, and I don't know, have we had any legal analysis, or do we have any advice from the prosecuting attorney's office about those old permits that require a hearing for revocation and otherwise don't expire, as to whether we have any flexibility to adopt a termination and to put those folks back into a lottery?
That is something you could suggest as part of a rule change that we would then run by the PA's office.
Okay,
But I
not at
don't-
this point, not at this time though. Right, got it.
Not at this time.
This is Dale. May I speak?
You may.
Thank you. Well, I remember on that subject, Tim, that we kept asking for a legal opinion or at least legal advice on our ability to set enforcement parameters and deal with these kinds of grandfathering issues. And we never got it. Of the final that was when the county council made their decision to approve the current amendments, which there was only 4 people in audience that day, the attorney did finally show up, and it was the first time I had heard any of the legal analysis on the ability to deal with at least the current, meaning the proposed permit requirements for being able to take a permit away. So I would renew that same request. But my question, Erica, is would you describe the enforcement process we have now as at all effective? And I say that based on how you're describing the difficulty, the time consuming nature, and the cost of dealing with anyone who chooses not to comply.
So I would say that, so as you recall, in 2018, we also put in new enforcement. Yeah, sorry. Anyway, when we put those regulations in place, we did add additional enforcement teeth for the unpermitted vacation rentals. And that works very well. It is a very big deterrent to the unpermitted vacation rentals. At the time, I don't think we realized how many of the existing vacation rentals we were going to have that would go through our standard enforcement process which requires a notice and a notice of violation and a hearing. We could look at the possibility of shortening up that process. What we would do is we would probably create a docket, and we would standardize our forms and letters and things that go out to these folks. But it's just still a big job. But my thought, I do think when we did the first round or the second round of compliance, what we did was with the people who weren't in compliance, we sent them a letter saying, "You're not in compliance. Do you want to abandon your permit?" And so we got a lot of people that did actually abandon their permits. So my thought is that with these ones that are 170 that are really haven't complied, is that if we actually issue a notice of violation, we would probably still send them a letter. We try to be helpful when it comes to enforcement. We send people lots of letters and give them chances. We would probably send them a warning letter and say, "Hey, do you want to abandon your permit? If you do, please send it back. Send this back to us. Otherwise, you're going to end up with a notice of violation, which has a $500 fine with it, which we would issue, and then we would set a hearing date and let them know that they can show up at the hearing."
Erica, I think the one thing we learned 2 years ago was how many compliant vacation rental owners are out there. And I mean, they showed up in droves, and I have to say, I think we were all impressed. At least I was, at how diligent most are. So what bothers me is whatever limits we have, whatever restrictions we have, if it's costly and time consuming to enforce, they really aren't limits. And then we get a situation like we've had to deal with for the last several months, where we've had a higher priority than dealing with vacation rentals. And so now we take the limited number of enforcement staff people available, and we move them off that issue. So that's my biggest concern, is whatever regulations we have, whatever limits we place, that if we really don't have an efficient, meaning ability to afford to enforce set of restrictions, we really don't have anything. So that's I'm curious for your reaction to that.
So yes, I agree that we should be looking at when we make regulations that they are easy to enforce. And so I'd say the really good example of that was the enforcement for the unpermitted vacation rentals. We made it illegal to advertise an unpermitted vacation rental, and we find the illegal advertisement. We send out a notice of violation. We have it standardized. It's quick, it's easy, and very, very effective. And I think I think this would be looking at these regulations would be looking for, and what we've tried to do with the options we've provided are things that we kind of already know how to do and are easier than other options out there. And I would say the example of that is some places have a residency requirement for people that are vacation renting, and I think that there is some appetite for that here. But that is a highly involved and kind of difficult thing for us to regulate on an annual basis to make sure that somebody is still a resident who has a vacation rental permit. So, that's kind of the example I would use. We weren't prepared. I don't think we had thought about when we did enforcement that we were going to get 170 and have to go to hearing on all these 170 permits. So that's just the way our code enforcement, is set up.
So, Erica, does the enforcement primarily come from the planning department as opposed to the prosecutor's office, or when there's public hearings, are they then conducted by the Attorney General's office, or the prosecuting attorney's office?
No, hearings on code enforcement or any decision or action that our office takes is appealable or heard by the hearing examiner.
Okay.
And yeah.
And then the cost of a hearing examiner and being involved with one of those appeals, do we have a rough idea as to what that costs the county per incident?
For the vacation rentals, I don't, because I haven't. What I would intend to do with these is I would set up a docket of hearings. Like we would just set a special day aside that's the hearings on these and tell people when they needed to show up for like a docket of them. When it comes to actual appeals, though, of any kind, either appeals of notice of violations for enforcement actions or appeals of other decisions, it really depends on the nature of the appeal. If people are, it's an open record appeal. Folks are allowed to have their attorneys present. They're allowed to call witnesses. It's a very much oriented towards making sure that whoever has the grievance against the county is able to be heard.
Yeah, I think that just adds to my concern.
Are there other commissioners who would like to weigh in here?
Well, this is Tim. I will be bold enough to say that I think we do need to establish a limit. But the concern I have is with this large number of older permits, because I think it's very unfair to pull up the drawbridge at this point and say the only way anybody gets a permit now is if somebody else goofs up or decides they don't want it anymore. Because that's, in essence, to me, just entirely inconsistent with the idea that people ought to be able to find a way to make a living using their property. And I understand the problem. I mean, obviously, we've heard this for a long time, but we have a problem that we have inherited from county folks who were here before us and who adopted a system that essentially provided vested property rights in essentially a particular activity that we understood and acknowledged even at that time we had the right to regulate. That was a bad policy decision, but we're sort of, at least at this point, stuck with it to some extent, and we still, and I'm pleased that Dale reminds us of this, haven't received any advice about what the potential legal parameters of changing that are. And so we're sort of stuck with an idea that, yeah, it would be great if we could, I mean, not great necessarily, not for everybody, but we have to have some, we have to have a system that works here. If we could start from a clean start, we could pick a number and we could have a lottery. And if we had a lottery, I would make a recommendation a little bit different than this. I would have a lottery that allowed somebody to have a permit that would run absent revocation for some period of time, so that they were able to recoup the time and energy of getting the place up to scratch, putting the policies and procedures in place, and all those things. So it wouldn't be every year that everybody had to re-up, but on some rolling basis to make things rational for the department. Unfortunately, we've got this grandfathering problem. We've got these permits that run with the land because that's how it was done before. And my concern is, I think we're going to be stuck with major litigation if we try to be fair about the way we set up a lottery. So that's my concern. Otherwise, I think setting up a number of them would make some sense, and I think we'd need some additional data and sort of some agreed upon numbers in order to figure out what the right number is. And I don't really know, but I suspect island by island would make some more sense. Would make more sense as opposed to a county-wide cap, just in terms of trying to address the concerns that have been raised. But that's my initial thoughts about it. I'd like to find I'd like to come up with a way to have the distribution of those permits be fair, recognizing that what seems fair may depend on where you sit.
This is Adam. In terms of our discussion today, if there's data or some kind of analysis that would be helpful for that, or that you haven't seen that you would like to see, this is also a good time to ask for that. We can come back with some of that.
Well, Adam, what I had in mind is I'm not sure what would help us pick the number, other than plucking it out of the air, because we've got folks who tell us it ought to be almost nothing, and then we have what the market has generated to date in terms of folks who have complied with the rules, right? And so that's a number. I don't know that there's anybody arguing that it should be a bigger number, although there's perhaps somebody who would, I suspect there are individuals who'd like there to be at least one or two available slots that they could vie for as a practical matter. But again, that's what I don't know. I don't know the answer, and I don't know on any reliable basis how to come to a carrying capacity of vacation rentals question. And I would also further note that everything I said before is also subject to criticism because it doesn't address the neighborhood saturation question and how we would define a neighborhood or how we would define saturation and how we would administer in even a lottery that addressed the neighborhood concern, because that situation just outside of just south of East Sound is certainly not the only neighborhood that has lots of dots.
Right.
And a cap might not even address that in any way.
I think that's kind of the idea behind having a minimum lot size. As we were working through this internally, like that, it may not address how many per neighborhood, but it would certainly address how many vacation rentals essentially per acre you could have. And so in some of those neighborhoods with the smaller lots, if we had a minimum lot size of say 5 acres, that would really cut down on those neighborhoods with very small platted lots being kind of inundated because they wouldn't be allowed in there anymore. So that was the thought behind that minimum lot size as maybe one of the ways that we can get at that particular issue.
How would you integrate that with a lottery decision, though? Oh, sorry, I talked on someone again.
Well, it wouldn't necessarily be the lottery system. It would be one of our performance standards would be that it couldn't take place on a lot larger than or smaller than X. And then regardless of, they just couldn't apply for it then. Just like we do with accessory dwelling units require a minimum lot size in rural areas. And so if you have a 3-acre lot in rural farm forest, you just can't have an ADU, a detached ADU. So it would be a performance standard, not necessarily a cap on the number. It wouldn't necessarily relate to the lottery.
I see. I see.
New permits that would be, that's all. I mean, it wouldn't affect any existing permits.
Correct.
Yeah. So back to Dale's point about asking for legal advice on some of these issues. Is there any sort of precedent for the 100 and some on non-compliant people that if you issue a moratorium, just say if you don't respond by XYZ, you lose the right to appeal? I don't know.
This is Erica. Yes. No, I'm not sure. I think that in order to revoke somebody's permit, I think you have to give them the opportunity to hold a hearing. Now, it could be that they don't show up, and they just let it go, and then the permit gets revoked. But certainly, if you wanted us to look at different options in terms of enforcement for those old permits, I'm happy to do that as part of the information we could bring back to you.
Okay.
Can I ask one other thing? It's been suggested to me a couple of times by folks who weren't able to provide any citation to authority for the proposition that while we might have trouble with some of these, but we could just we could terminate. Is it possible? And this is another one of those legal questions that I don't know the answer to, but would it work to totally terminate vacation rentals and start a new program rather than on a case-by-case basis go through and do away with these? I'm not expecting you to have the answer to this, but this is why we need lawyers to kind of give us an idea of what makes sense, because certainly the county council is going to want to know, and we shouldn't spend a lot of time carefully crafting something if it's dead on arrival. And it would be good if something is dead on arrival as a concept or is not something that can be done, to have that be known so that people can be told that. He says, although recognizing that we continue to hear other arguments where the legal issues are resolved and they continue to be thrown up at us anyway. But it would be good for us if we were able to say that we have advice that can't be done, so stop asking us about that. And let's talk about what we can do. No, I'm serious. I mean, we need to be talking about what we can do and not pie in the sky stuff that doesn't work or cost the county, more money than the county's willing to spend defending itself. That doesn't make any sense. We need to be identifying what can work and then figuring out how best to implement something like that. So if there were a possibility to completely terminate the program and start over with a new lottery and perhaps some enhanced performance standards as have been discussed, that's one thing. We could decide, and the county council could decide on a political basis whether that's a decision it wants to make, and then we could spend some time trying to figure out what the right number is. On the other hand, if that doesn't actually work, and there's no way that works, and the high likelihood is that it's a loser at the state Supreme Court, then we're fools to continue to go down that road.
This is Dale. I'm back from having been cut off, and I'm now reconnected. I hate to cut other people off, and so I'll back off if somebody else would like to, speak to these issues. But I want to pick up on the need for some sort of guidance from the legal fraternity.
This is Erica. So what I need to know exactly what it is you want to do. That
Okay.
Like for example, what Tim said, which you may have missed, was can we just cut off or terminate all permits and start over again? Now, if that's what
I think
that's a question I'd like to know the answer to.
So, okay, more generally, Erica, I would think that the issue would be posed to the legal advisor if we were to set a limit, absolute limit that we determined was fair and reasonable. How can we adopt a new regulation amendment, or, as Tim has suggested, revoking all laws before dealing with BRs and come up with a new one? If that's so, you pick the way, but how do we come up with a process, having created regulations, some of which might just be not making noise that affects neighbors down the road? Whatever it is, give us a plan so that there's a way that it doesn't cost us more than it is worth to enforce. And let them be the creative person deciding what ways to do it. And we can certainly offer them suggestions. You and your staff obviously are learning things on the road, and Tim's got his experience, and others here on the Planning Commission might as well as the council. So I would think but that's the general question you want to pose, because we have not been given that information. We've thrown out ideas of enforcement, and so we got enforcement, but now the enforcement we have has taken 2 years, and it isn't really off the ground in an effective way, despite your efforts. So that's the way I would approach it.
So I would like to respond to that, because I wouldn't say that our enforcement is not off the ground, because it is off the ground. We issued $100,000 in fines for unpermitted vacation rentals based on the new fines and regulations that you recommended, the Planning Commission recommended. So, and then on top of that, we have done, compliance certificates online, and we now have numbers, and we have people reporting into us. So the program is working, enforcement is working. What I haven't done is the the final piece of the 170 permits that haven't turned in their certificates of compliance, and I think that was somewhat unanticipated. I don't think I realized that there were going to be that many people who didn't respond to our repeated reminders out there. So I think you need to step back and think about it, because the program is actually, we've done a lot. We've done a lot of enforcement of it. And I guess the next piece of this is County Council has directed me to actually prepare a fee for vacation rental certificates of compliance. And they really feel that once there's a fee in place, that people will decide either they want their vacation rental permit or they don't want their vacation rental permit. And that fee is to pay for the person pay for the program. So we are moving along, and we're making a lot of progress. So I think I do think we need to think about the progress that we've made, as well as what we still need to do.
Okay, I will restate that to say there's still a lot of people with permits who are getting away with not complying. And it's a large percentage. Is it not 25%, something like that, maybe 20? Of the active.
There are 170 folks that haven't responded at all. Yeah. My guess is that those people are not actively renting. My guess is that those are people that, for whatever reason, they're either not renting, so they don't think they need to, turn in a certificate of compliance. Those aren't people where we've got a complaint that they are doing something that's not in their permit. Those are just people that didn't turn in their paperwork.
Right. And it would be great to know that, for purposes, getting back to Tim's point of knowing how many vacation rentals out there are actually being operated today. So we could set a limit based on the current number that's been issued, if we were to put a hard limit on the total that are out there. But if 170 of those are inactive, then if we're going to set a limit that limits it to those that are being used actively now, it'd be 170 less than that number. So So I think somehow getting information, and it's, I guess, very difficult to get, is taxing our ability to come up with a fair and therefore maybe justifiable limit on vacation rentals. So anyway, but I truly appreciate all you've done. And I didn't mean to say you hadn't accomplished anything. I just think we've left ourselves such a big task of, one, legitimizing our system or our process by allowing so many people to disregard the regulations that are currently in place, and it's, you know, it's going on a while. And for you guys, once you identify those who are really going to resist this, then we'll learn even more as to how much it costs and how much time it takes, and all those things are concerns that end up leading to new regulations that would apply to all those issued new permits going down the road, as to how to deal with them so that we don't repeat it, unless we can do as Tim suggested, erase all the rules before and come up with new rules that truly are effective at controlling the way VRs are operated and those who get to keep them. Anyway, thank you so much.
So, Erica, could you just restate, of the 170 that are non-compliant, these are people that are not actively, you know, to the best of your knowledge, are not actively renting their properties. And so it's a question of following up with them to say, no, you still have to be, you know, sending your paperwork for. I mean, there's just administrative steps that need to happen to clarify that.
Yes. So we have all entered all of these certificates of compliance into our databases, and I am able to provide reports that are on our website that show you how many we've received, of how many people have actually turned in certificates of compliance, and it shows you whether they're active or they're inactive for the ones that are submitted. And then we have about, I want to say there's 150 that submitted something in 2018, but not 2019. So to me, that is a reminder to those folks to submit. They need to turn in their certificates. And then we have 170 who didn't respond in either year. And so, but that's out of, I want to say a total of 900 and,
right.
I can't remember off the top of my head, as of April 30th, there were about 900 that we were managing. So
I think it was 963.
yeah.
So just to kind of recap where we've gone here. So you've asked for some more data on what would be a good number to set a limit, a hypothetical limit at. That's one of the things that you're looking for. And then second, you're curious about the option of possibly wiping the slate clean or getting basically starting back at zero with vacation rental permits. And what does that look like, and is that possible? And then kind of related to that is also more information about possibly having that kind of retroactively apply to existing permits that have been kind of grandfathered in or are non-conforming to whatever we eventually end up adopting. So those are the three things that I've heard you want for next time. In terms of the issue here, issue one about setting that limit, it seems that you're most interested in setting a cap on the total number allowed, and probably by island, and less interested in setting a cap annually, but not capping the total number. So maybe if you could elaborate on that and give kind of clearer direction about these options here on the screen for issue one.
Yeah, well, you really don't have. I mean, this is Tim. I think you're taking that from what I had said, because I haven't heard my fellow commissioners weigh in, at least not at a consensus level yet on the fundamental question or the individual options. To me, and a limit on the annual rate of increase doesn't actually seem to be the right answer. It seems as though we actually do have a problem, and we should, at least in some areas, we have a problem, and that's why I raised the question about whether this cap would even address some of those things. We may need to do other performance standards that are rationally related to the other issues and evaluate those. But if we don't set a cap, if we just set a rate of increase problem, then all we're doing is kicking the can down the road and incurring incremental damage in the meantime. So that doesn't necessarily make sense either. Now, theoretically, you could set a cap and not reach the cap, but that's not where I think we are as a practical matter in our situation, which is why I had raised those issues. As far as the clean slate goes, the clean start doesn't get us anywhere unless it includes addressing those existing permits. Now, I certainly have friends who've had permits for many, many years, and it seems this could be, not it seems, this could, if that's what we did, and I was just trying to move us along in the discussion. If that's what we did, it could be very disruptive to individuals who have been in the island for a long time and have well-established vacation rental operations and do a great job with it. But it's how they make their living, and it's a completely legitimate, completely consistent with rural character, completely consistent with earning your living off the use of your property. As far as I'm concerned, that's my view. On the other hand, there has to be some fair way of setting this up, and the lottery proposal we have doesn't quite address it either, because if you threw everything up in the air every year, that's a ton of work for you, and it interferes with inconsistency, it interferes with return business and season over season advertising and that sort of thing, which isn't good for the community as far as I can see. So there's more that could go into that, but I do think that some system like that sets a cap makes some sense. I would take a step further, though, and there are a couple other questions, Adam, as you were taking these things down. I'd be very interested what proportion of vacation rentals are on lots smaller. Now, there's some data in here. You do provide some data, but if one were to look at in option 1D of the is it correct that 465 out of 603 parcels are on less than 5 acres? So
let's see here.
I was taking that from page 11 of the staff report. So if that's true, that's not a very convenient cutoff point. So
right.
So, I mean, if you made it, I suppose, then if we read further down, if the average size of 349 of the current rental parcels is 1.6 acres, that suggests that 2 would even perhaps be a fairly drastic point. So maybe so I don't know, it depends what you're trying to address there.
Yeah. Well, the idea is that if the minimum lot size idea is that basically then it's kind of like when we were looking at marijuana regulations too, like on larger parcels, the impact to surrounding property owners is going to be diminished because there's just going to be more space between where the activity is happening and neighboring residences. So that's part of the idea behind adopting or setting a minimum lot size. Also, that can help kind of control the saturation, because in a lot of these neighborhoods, like the one that we have the example of from East Sound in the staff report, that the average lot size there is about 1/4 of an acre, and you can see just how close those houses are in that neighborhood. And so, if that was on a larger lot, that just spreads that out more and cuts down on some of that kind of per acre saturation. So that's the idea. I think we can definitely look at what that would do to set it at say 2, and how that might impact the current numbers and current vacation rental permit situation.
Well, where I was going was further than that, and that is to get more granular and look how many of them are on very, very small size lots, so under an acre. Because as you noted, that does exist, where under 1 acre lots are there, and some of those even outside that that one photo that's here, there are certainly others that are that, and I have no idea what proportion are on smaller than an acre even.
So let's see here. So this
the reason for asking that is by approaching it as a performance standard, we're really sort of saying that there is really sort of reaching a conclusion if we're being rational about it and not just drawing a line for the arbitrary purpose of excluding some vacation rentals from the potential marketplace. What we'd be saying is that under a certain size, the externalities associated with the operation of that vacation rental business are, in our view, too high, and are much more likely, because we can't say with certainty, but are much more likely to interfere with the rights of neighbors, if that's what we're saying. So where's that line? And granted, we can't say it's true in every case, but we could reach a finding, particularly if we undertook the exercise, asked the question, got responses and feedback through a public hearing and things like that, to draw a line like that based on the county's police power, for example. I think, not giving legal advice, but I'm thinking that that's something we could do. Mm-hmm. And I'm thinking that that's something we could do even retroactively, but again, I'm not the county's lawyer. So I've been trying to think through how we could come up with this sort of thing in a fair way. But one of those things is I don't want to go through that exercise, and I doubt the prosecuting attorney wants an entirely hypothetical question. So consequently, I think it would be good to know the breakdown of smaller lot sizes in order to evaluate option D. And I also sort of think option D should be a different kind of a question. It really shouldn't be option D under issue 1, because as you noted, it's essentially a performance standard. It has nothing to do with a cap or a limit on the number. It has to do with a performance standard, so of not allowing them on a certain size. So I would carve that out because I think it's a different question that would operate independently of a cap of any variety.
So moving forward, do we want to go back, forward and back? Tim, are you still interested in soliciting the opinion of the prosecuting attorney as to whether we could call a halt to the whole thing and start over again?
Well, what I would ask is this. I didn't want to jump to a conclusion. I started early on to try and get some concepts out there, and I hope that's appreciated. If not, I'm sure folks won't be shy and will let me know. I'm interested in how other members of the Planning Commission feel about the idea of establishing a cap.
Okay, well, let's poll the commission. David, how do you feel about establishing a cap? And
I am still contemplating this at this moment. I'm not ready to have a strong position on this. I think there's too many variables out there right now.
Okay. What about you, Dale?
I would be for a cap if I had more information. My fear is that we don't have enough information to know what a fair cap would be, but that doesn't mean we shouldn't have one. I can't believe we can't have one. The city of Cannon Beach, we looked at their regulation 2 years ago. They set a cap of 500. I'd really be curious how they set that cap of 500. That was back in 1992. So they've got a lot of history with that. So apparently it can be done and it can work. Anyway, that's my answer.
Steve?
Yeah, I'm in favor of a cap.
So, Adam, I believe you've looked at other areas where this is a major issue. Have you ever looked at Cannon Beach? And
I did not look at Cannon Beach and getting prepped for here. I would say that if it was enacted in '92, this is a problem that's become much more pronounced in the last 20 years with the rise of like Airbnb and VRBO. And I think those internet platforms have really changed how prevalent this issue is. But yeah, I don't know about Cannon Beach off the top of my head.
I bring up Cannon Beach as an example because Tim brought up the issue of potentially putting a time limit on these, and that's what Cannon Beach did. They had a 5-year limit, and once your 5-year period ended, you went back into the pool, and if you wanted to be considered again, you'd add your name to the list, and I don't know if it was done on a lottery basis, or whatever. So that's the way. Part of it was the whole overall plan they had, and whether it appears to be still in law. I mean, it didn't indicate when that information was provided to us. I can't recall who in your staff provided it, but it seemed to be still an active law. So anyway.
So I did see in reviewing regulations in other cities and places that have encountered this issue, some folks have adopted where it's more like a business license than a land use permit. And in that way, it has kind of this sundown clause at the end where after 5 years or whatever, it expires and you have to renew your license at that point. So that's a little bit of a different way of treating it than as a land use permit, which typically does run with the land.
So
Right.
So Adam, do you think that we could or couldn't approach it with a business license approach? Are we somehow hamstrung in not following that lead that other municipalities and jurisdictions have followed?
Not necessarily. I mean, I think we would still run into the problem of the existing non-conforming folks. I do think our annual certificate of compliance is very similar of a mechanism. It just doesn't necessarily enforce a cap. But in terms of getting folks to at least annually submit something that's signing their attestation that they will comply with their permit requirements is a step toward that in a way that we didn't have before. And it's very similar. It just doesn't have it doesn't enforce the cap. Yeah.
Right.
Or a cap.
Okay.
Adam, I got a question for you. David Kane here. So have we looked at this from a standpoint of, well, I guess the first question is a vacation rental a residential use that's consistent with rural character, or is it a commercial use that's consistent with rural character, or is it neither? And then the next one is, have we looked at managing this from a standpoint of, if it is a commercial use, from a standpoint of life safety? Is this, if it's a commercial use and it's a accommodation, is it now a hotel, and should we regulate it like a hotel with the same rules? And I know there's other jurisdictions around the country, like Jackson Hole, Wyoming, which is a really similar population size to us, but with about 4 times more tourists per year. They chose to regulate their vacation rentals with saying it's a commercial use, and we're going to enforce life safety requirements, i.e. fire sprinklers, in these things just as if they were a hotel. And they have been seemingly very effective in managing their vacation rentals with that strategy. So I don't know if we've looked into any of those, that angle, because I don't think that's one that's been brought up today.
So can I answer that, or?
Please.
Yeah.
So go ahead.
Okay, so in the existing comprehensive plan, the county has adopted a policy that states we will that vacation rental is a residential use that will be subject to performance standards similar to a commercial use. So that's why our code now categorizes vacation rentals as a residential use. In terms of the life safety requirements, with our certificate of compliance, there each property owner has to certify that they have smoke detectors, fire extinguishers, those kinds of things when they fill out the certificate of compliance. So we do get at the safety concern in that way. And each new permit the driveway has to be inspected by the fire marshal so that it has adequate access, those kinds of things. But in terms of the fire sprinklers, we don't require that now.
If I might add, for the benefit of the group, the reason that our comprehensive code and our code treats vacation rentals as a residential use is because that's the law in the state of Washington. The Washington Supreme Court has held, and there's even a Washington Court of Appeals, a lower appeals court decision involving San Juan County, involving Cattle Point, actually, that reaches the conclusion that a vacation rental of property is identical to the use of the owner's use of the property as a residence, or the use made of the property by a long-term tenant, and that the receipt of rental income on a short-term rental in no way detracts from those characteristics, that you use it to live in, sleep in, that sort of thing. So these were cases that, and the Washington Supreme Court agreed with that, or actually followed this separate lower court decision. So there's several decisions that reached that. And the way these cases arose was in disputes between landowners who wanted to have short-term rentals and their homeowners associations. And the reason for the dispute was that the homeowners association covenants were not drafted in terms of can't have a rental less than 30 days. They didn't say that. They said you couldn't have any commercial activity. And the court held, okay, too bad. They didn't violate those because this is not a commercial use. This is a residential use. So that residential versus commercial is a little bit different than is it a business? Because pretty clearly, based on, as was described earlier, you can have a residential use that's still a business and could still be regulated on a business license basis, but it's still a residential use, not a commercial use. And notwithstanding three different sets of comments that we have received in response, in preparation for this briefing, it's not a commercial use. We're not going to be able to make it a commercial use without going to the Supreme Court. So the question is how to regulate this residential use in a manner that's appropriate. And what our comprehensive plan says we're going to do is to look at it similar to a hospitality accommodation. And while that seems a bit strange, that's kind of where that is where we are. So can we do that? And I think a business license approach actually would make as much sense as a land use permit. I can understand how we got here, but the land use approach is how we got to this situation of perpetual permits. Yeah, in fact, you could continue to use the property that way if you had a business license. So that's the other question. The other way I would phrase the question, if we had a lawyer we could actually get advice from, and that is, okay, you've got that permit. If maybe we just layer on top of it a business license. How does that work? You've got a land use permit, but you can't have a vacation rental unless you also have a business license, and we're only going to issue X number of business licenses. So you could have a situation where, according to the land use, you could operate a rental, but you can't because you can't get a business license. Could we do it that way as a mechanism for setting a cap if we wanted to? But it's getting frustrating because we're sort of stymied. We can't just make this up.
That's right.
So But also, can I? I mean, the other issue is let's think for a second. Even if we want to set up, even if we decided, and I'm not saying that this is where I come out necessarily, but let's suppose for a second that we decide that we think an overall cap makes sense for the county in terms of preserving the overall resource that is the beauty of San Juan County. So it makes sense to set some sort of a cap, supposing we decide that. And then supposingly we decide that there's a mechanism. Suppose it's this business license layer approach, or maybe it's a wipe out the other permits approach and start new. Whatever it is, supposing we can do that, then it seems to me that it makes sense to us, and this is just my view, but it makes sense to us to evaluate whether folks who've been operating for years and whether folks whose sole source of maintaining themselves is and has been for years operating these businesses should have some sort of a preference, perhaps. Perhaps not, but perhaps. There's also been the suggestion in some of the comments that we've received that we should be drawing some distinction between a rental of a room versus a whole house rental on a less than 30 days basis. And there's also been a suggestion that we should have a preference for people who are themselves residents of the county or themselves residents on the parcel that they're renting. So all those things would complicate a lottery system potentially, but wouldn't necessarily undermine it if we were to think of those things too. But before we spend a lot of time working those things out, I think we'd have to come to some conclusion that we felt a overarching cap made sense. And I'm not trying to rush this. I'm just trying to get stuff out there since we're not in the same room. I apologize if this seems overbearing, and it's not my intention.
Well, I think we did take a straw poll at least as to whether the commissioners thought we should have a cap. And
right.
I think you said yes. Dave said we have enough information to make that comment. I believe weighed in with the approval of the cap. Am I misstating anybody's intention?
I thought that Dale didn't have enough. I mean, he would vote for one. He wasn't.
Yes.
Enough
Yeah, I would vote for one.
Dale would vote for one. Okay. And so Tim.
Let's assume for purposes of the record that it would have to make sense before we would vote for it, but conceptually, right? That's what we're talking about.
That's correct.
You are a strong, yeah.
Okay, so what I'm hearing from that is that you're interested in possibly setting a cap should it make sense, and you'd like a little bit more guidance on the possibility of maybe instituting like a license type system that would enforce like a cap on an annual or semi-annual basis. You're curious about what are the legal options for kind of resetting at zero and whether or not that's possible or makes sense or is fair. And then also kind of related to that, like how do we get these what are some mechanisms available to address like existing permits and existing nonconformity? Those are kind of the things that you'd like some more information on next time. Does that sound
one
right?
More.
There's one more.
One more, and that is putting a time limit on the whatever you call it, the permit, the land use designation, whatever it is. So.
Well, the term of the permission, whatever it is.
Term of the permission.
If you think of it as the term of the business license or something like that. However, and the only reason I suggested that is just trying to put out some ideas that, an appropriate lawyer could research.
You also mentioned resources, in other words, impact on water, health and safety issues, and
yeah, I mean that would be the basis potentially for the county to exercise its police power, right, to protect the interest of the county and of citizens at large in the county and those other things. So health, safety, morals, all that sort of stuff that, well, you may not have read all these cases, but they're out there about the exercise of police power, and that would be the reason that one might rely upon for implementing a business license above and beyond the land use permit, which would seem to me to be one way to go about doing this. You wouldn't have to revoke the land use permit in order to say that, yeah, you have a land use permit, but you don't have a business license, so you can't operate.
So Linda, I think, wants to weigh in here as
Well, I think
point of
that,
order, maybe.
yeah, point of order. I understand the general discussion on all of these items, but we are still in a meeting. The chair is supposed to be running the meeting. Sometimes she has a hard time getting through to be able to speak or recognize somebody. That's okay too. I mean, that happens. We're not all together. If you're going to go with the list of items that Adam has put together, it would be nice to know from the chair or somebody that those are the items that you want to go forward with, as that allows me to actually write down those things, that these aren't just a general discussion, but actually items that you do want forward. So it's not just the planner, it's not just the planning commission. It needs to be a group that this now are the things we're going to list, and these would like to be the items that we would like to take forward. Adam has a list now that sounds like it's pretty agreeable to what you're doing. So maybe if you decide that is the list that you would like to go forward with, I will get them from Adam then, because until I know that that's something that you need to have written down, I'm not writing it down. So go ahead.
So, Adam, you had a fairly comprehensive list, and we talked about adding, resources as another element of that list. Are there other additions, or should we move forward?
Move forward.
Okay. So move forward. Linda, you'll get the list from Adam.
Yes, I will.
Okay.
And that's by consensus, I take it.
We did.
Okay. So moving on to issue 2 is whether or not vacation rentals should be limited in the UGAs to avoid overconcentration of vacation rentals in those smaller lotted neighborhoods or platted neighborhoods, and promote the availability of long-term rentals. This really gets at that issue we've talked about a little bit already today, is that a lot of these smaller residential lots kind of lend themselves to some of the bigger problems from vacation rentals because they're so close together. And this typically takes place in our urban growth areas. I mean, there are other neighborhoods kind of throughout the county that have these smaller lots, but this seems to be more pronounced in the urban growth areas. And another kind of related issue is that in our urban growth areas, accessory dwelling units are allowed to be vacation rentals. And both the house and the ADU can be used for vacation rentals on the same property. Kind of exacerbating the issue is that ADUs are typically smaller and are much more likely to be affordable long-term rentals, even at a market rate, just because they're smaller in general. So here's an example of a neighborhood in East Sound. This is at the southwest corner of the urban growth area along Orcas Road, right before you turn right onto Main. And we can see here the green dots are active permits, the tan dots are those inactive permits, and then the red dots are folks that have a permit but haven't submitted a certificate of compliance as of April of this year. And about 19 of these 36 smaller lots in, here I'll zoom in on the neighborhood just so we're all clear. So about 19 of these lots, of these 36 smaller lots have a permit, And all of these lots are about a quarter acre each. So that's at that 4 units per acre density. And this, again, happens much more commonly in our urban growth areas because we have fewer regulations on the number of vacation rental permits allowed on the property, and we allow these much smaller lots to be created still. So some of the options for addressing this are to prohibit vacation rental in accessory dwelling units within the urban growth areas and limit vacation rentals to 1 per property in the UGA. The benefits of this option are that it may reduce the number of affordable dwelling units that are used for vacation rentals. And it also limits the vacation rentals in these denser neighborhoods in the urban growth area. Some of the drawbacks of prohibiting vacation rentals in the UGAs is that they typically have most of the retail, restaurant, and other services that tourists seek. And vacation rentals in the UGAs might reduce the vehicle miles traveled by tourists because they're closer to those services. The UGAs are designed for more intense development in general. And so the vacation rentals here are going to have less of an effect on that kind of rural character because they're focused in the UGAs. And then option B is to allow vacation rentals in the commercial designations in urban growth areas, but prohibit them in the residential designations in the UGAs. Some of the benefits of keeping it just in the commercial designations is that it will focus this activity more in those commercial areas where impacts to residential uses are much less likely because they're already designated for commercial. And then prohibiting the vacation rentals in these residential designations can really reduce the impact on some of those dense neighborhoods in the urban growth area. The drawbacks of limiting vacation rentals to only those commercial designations is that homeowners in those residential neighborhoods would not be able to get new vacation rental permits. And as we kind of talked about a little bit earlier, some homeowners really rely on that income to afford to live here. And then finally, option C is the no change option, which some of the benefits are that we wouldn't be committing any additional resources to kind of making changes. And the option C is really fair because it's not really changing who can get a permit. It would keep the status quo. But the drawback there is that it wouldn't affect the number of possible affordable dwellings in the urban growth areas because accessory dwelling units could continue to be operated as vacation rentals. And making no change here would not affect the possible impacts to some of the densest neighborhoods in the county. We can, as we discuss this issue, we can consider some combination of maybe A and B as well. So maybe only limiting or only prohibiting vacation rentals and ADUs in the urban growth area or something like that. So we have some flexibility here. So now I would turn it over to discussion of this kind of issue of vacation rentals in urban growth areas, East Sound and Lopez Village.
But again, you're speaking about new designations, not existing ones.
Correct. This would only apply to new vacation rental permits.
So you already have a lot of density in that one neighborhood in East Sound.
Correct. Yeah. And any dense neighborhood could end up. This would impact any of the existing designations kind of throughout the urban growth areas.
Okay, well, let's start from the back and go forward. Steve, what's your...
Oops, there, I just mute myself. I'm not sure whether limiting these vacation rentals in the urban growth area, I'm not sure whether that's going to have any effect on the availability of long-term rentals. low income rentals. So I'm unclear about that part.
So the idea there is that kind of by nature, the accessory dwelling units they're typically smaller. They're less than 1,000 square feet, and if they are made available for rental, they typically will be at a more affordable market rate. And the concern here is that by allowing those ADUs to become vacation rentals, that's basically allowing what could be a potentially affordable unit to be used as a vacation rental. So that's the concept behind that.
Okay, that makes sense.
Dale, Randy?
I didn't quite hear. Were you addressing me, Dale?
Just asking if you had comments about these two policy options.
Well, I do, but I'm not sure I've formulated them yet.
We'll come back. David?
Yeah, David Kane here. Yeah, so for the policy option A, prohibit new vacation rentals and accessory dwelling units in UGAs, I don't know. I think that if we are going to, I'd like to concentrate any growth and any commercial type activities like vacation rentals in the UGA, and I think that helps us protect our rural character. When we let that out into the wild everywhere else, I think it diminishes the rural character for everyone. So I would sort of, I would like to see that these uses definitely allowed in the UGA. And as far as allow vacation rentals and commercial designations, that's option B. To me, I wonder if that displaces other desirable commercial activities within the UGA. And then we have this, we displace those users and create, fix one problem and create another. I think it's very difficult to be a small business owner here. And if you're competing with vacation rentals for rents on something within one of these UGAs, that's something of concern. However, I will put a big asterisk on all that, and I don't really understand the Lopez UGA or the East Sound one. I live in Friday Harbor, so we have the town of Friday Harbor managing this in our case.
So this is Adam. For clarification, it should say continue to allow. So in East Sound and Lopez Village, vacation rentals are currently allowed in our commercial designations. The idea here is that you could prohibit them in the residential areas that kind of surround the UGA, and then in that kind of commercial core that's at the center of the UGA where we have our restaurants and grocery stores and things like that, you would then continue to allow it in that kind of commercial area. So that's just for some clarification on that.
Yeah, and as a follow-up, I think we need to decide if this is a residential use or it's a commercial use, because I believe it's sort of currently both. It's not really clear, and I think that would help us with some of these decisions if we there's a more clear definition.
I think our code is pretty clear that it's a residential use that's just subject to commercial regulations. I think it's more about what are the regulatory tools we want to employ to keep it from having these kind of negative impacts that we frequently hear about. And so if we want to kind of focus that in one area, keeping it to those commercial designations within the UGA will help kind of focus the vacation rentals in a place that's already designated for kind of more intensive and commercial use, or we can continue to allow it in those neighborhoods where it may have some additional impact to the surrounding residences.
Yeah, I still have a concern that we displace the bona fide commercial uses in those zones if this is in fact residential. So that's it for me.
Thank you. Tim?
A couple of questions. the question presented on issue 2, I believe, must assume that we do not put a limit on, we do not put a lot size performance standard for vacation rentals, because unless that lot size were very small, like smaller than 1/4 of an acre, then all of these existing ones in East Sound would become problematic, and we'd be drawing a line between existing permits and just saying no new permits on smaller than on a small lot size, whatever we drew the line back under 1D. Is that right? We're assuming that we're not doing something like that.
Right. Or, I mean, I think before we were to adopt any kind of change in regulations, we would look at it more as a whole. I think the idea here is to really focus in on the issue of the urban growth area, kind of holding issue 1 as a constant, assuming no change there. Because the UGAs have a unique challenge about them because they are more dense, but also they have this, they're kind of the focus of our commercial activity, and so they're kind of a unique place that we could look at the regulations for vacation rental there. But yes, we would assume that we're not setting a limit or a minimum lot size here.
Okay. The other is just a question for, I don't know if you have any data, but it seems to me that one of the implications of saying you can have a vacation rental in a commercial zone, but not in a residential zone within the UGA would be to potentially shift vacation rentals into your commercial zone. And another adverse impact that could have, picking up where on the thread that David started, it seems to me that there's a difference in the parking pattern at a vacation rental and at other, potentially anyway, depending on the size of the vacation rental. We could be congesting parking in the commercial zone as an unintended impact of concentrating ADUs there, not ADUs, vacation rentals there. Sorry.
Okay.
So I'm not sure I'm for that distinction anyway. Based on the current level of development in the UGAs, I'd have to talk to somebody who's got more of a futurist view, I suppose.
Well, certainly in East Sound, I think the parking is a perennial issue there, and it could definitely have some impact there because residential use does have a different parking standards than commercial uses. So we could look at that next.
Yeah, and I haven't thought it all through, but it's a thing that occurs to me as a potential impact of that type of policy decision.
So to help Adam here, do we want to take policy options A and B and either by consensus forward or decide that we are opposed to them? Tim?
I'm not sure what I think about these policy options because I think it would be dramatically affected by a decision we might make on issue 1. So in a vacuum, it's kind of hard to decide why we would suck vacation rental volume out of the UGA. Now, I realize there are people who live in the UGA, and there could be folks whose solitude and whatever quiet there is in the UGA are disrupted by a vacation rental, as opposed to someone who lives in a more rural setting. But I think some of that's to be expected by the choice to live in the UGA. I also suspect that to some extent you're in a better position to get sheriff's department enforcement of nuisances in the UGA than you might be out in a more remote part of the county. So I think those things probably balance out a little bit. And that would lead me to another question, though, because that's a supposition on my part. Do we have any information that we could look to that would tell us whether we've got a greater nuisance type complaint rate in the UGAs than we do outside the UGAs?
Adam, do you have any information?
I don't know off the top of my head. I know that I don't know. It's such our complaints about vacation rentals that we hear here for code enforcement, I think tend to be very case by case. It really depends on, we don't necessarily get like one batch of complaints. They're all pretty idiosyncratic.
Yeah.
So I don't know the rate off the top of my head, but we could look into. I could probably figure something out using our permit tracking.
I mean, where I was coming from is that if we're correct that that nuisance impact on neighbors and perhaps the general public is greater when we have vacation rentals in small lot sizes, then that would likely be correlated with the UGAs where lot sizes are smaller. If that assumption is true, and at the same time, there's that other countervailing thing. It would seem to be easier for the sheriff to enforce those activities. And what I'm talking about is really, I don't think that stuff ought to really be viewed fundamentally as a code enforcement matter because it violates other rules. It violates the sound ordinance. It violates other rules that we have in the county if someone's making a disturbance. So.
Right.
Okay.
So I'm not sure how I feel about it. I think if we had a cap, that things would likely wash out some, and I'm not sure why somebody who needs an ADU to be able to afford to live in their house in East Sound shouldn't be allowed to do that. It doesn't make sense. That would be a further ratcheting of ADUs beyond what we have done to ADUs otherwise. And so I'm not sure why that further restriction should happen, because it's a restriction on that person's ability to use their property to live in the county, and that's not right, I don't think.
My point, or kind of why this came up, the ADU thing in particular, one, our ADUs typically are brought up when we have public comments about affordable housing as kind of they're a possible solution for that. And then two, there's been a couple of developments in East Sound in particular where they were single family residences and ADUs that were almost purpose built for vacation rental. And we didn't have a good way of like limiting that ADU usage because of the way our code is set up. And so the thought was that if you're going to build an ADU and get that kind of added dwelling unit on your property, that maybe we want to make sure that that's going to be around for housing and not for this other kind of non-permanent housing solution. So that's where that came up from, was from some kind of specific development that we've seen recently.
Yeah, see, that just strikes me as not a proper, but that just strikes me as wrong, because if we want to limit the number of vacation rentals on a parcel or on a unit of area, that would be one thing that could be uniformly applied. But otherwise, that would dramatically change the rule to say you can only build an ADU if you're going to rent it for affordable housing, and that's just wrong, I think.
No, that's not what I was proposing. I was saying that we would say that if you've built an ADU, you can't use it for vacation rental. That's Not that there
Okay,
would
but
be.
but that's the same thing. But that's the same thing. Or what am I missing? If you have an ADU, you can't have a vacation rental.
Right.
Why not? Because right now we allow ADUs in UGAs to do it, so why change it? That way you got, how do you answer that in the situation where the person pays their rent for their primary habitation through the vacation rental? Why do we all of a sudden pull the rug out from under that person and not anybody else who pays their rent with a vacation rental that's legal? That just doesn't make any sense. I don't.
Could I just clarify the situation in East Sound? The situation in East Sound is that it's not that it's not limited to one per property. So we have situations where people own a house and an ADU on a property, and there's a vacation rental in each one. And this has happened many times. So that's actually the issue we were getting at. And I believe that because this happened in East Sound, that was part of the reason the moratorium issue came up, because right about the time these developments were occurring, where the house and the ADU both had vacation rentals in them, is about the time that folks decided maybe they didn't want to have any more vacation rentals in East Sound. So that's where this
Right.
came.
Yeah, but so wouldn't the way to address that issue be to say that this might be overbroad because on a large parcel it might not make sense, but in East Sound, wouldn't the way to address that be to say you can have one vacation rental to a parcel, or one vacation rental per quarter acre or per acre or something like that?
I think that's actually what option A was saying. We were limiting to one per property in the urban growth area, and it wasn't intended to say we're limiting accessory dwelling units to one per property in the urban growth area. What we were saying was that you limit to one per property, and that you don't rent out the ADU. Maybe you live in it and you rent out the house. That was the intent. But you could do any one of these things. You could just say one per property in the UGA, and that would take care of that issue as well.
Yeah, that's what I'm saying. I think one per property in the UGA would be a rule that I wouldn't have the same objection to. And it would also not overly limit what somebody could do on a 20-acre parcel either.
So, and essentially that's what A says, prohibit and limit them to one per property, right?
Yes.
So,
That's not what I heard Adam say, though.
Well, so there's kind of two parts of option A, and we don't have to take them together. One of the options is to prohibit new vacation rentals in ADUs, or we can limit them to one per property in the UGA. We could do both or one or the other. Sorry, it's a bit of a overly complicated for no reason. Yeah, that could have been simplified.
okay, should we try to see if there's consensus to limit them to one per property? Tim?
Sure. I don't fundamentally have a problem with that.
David?
Yeah, I'm amenable to one per property.
Okay. Dale?
That solved my issue. Yes, I would be for that option. Limit one per property.
Steve?
One per property.
The chair is one per property. Okay.
By consensus.
By consensus.
So if I may, Adam, is this a new A or is this an A1? Or do we need to say?
It's just it's a modified A.
Okay, so new
limit vacation rentals to one per property.
Right. So a new A by consensus would say prohibit new vacation, limit new vacation rentals to one per property in the urban growth area. Does that sound correct? Planning Commission?
Does anybody have an objection to that?
There we go.
And that's the feel by consensus. Okay, so that takes us to item D. The commercial designation. Allowing them in the vacation rentals in the commercial designation, but prohibiting them in all residential designation gates. Let's see if there's consensus with that. Jim?
I don't have enough information to conclude that that makes sense.
Okay.
Yep.
That's Dave.
I would disagree with that at this point.
Okay. Dan?
I'd vote for no change.
Okay. And Steve?
I don't have any comment on it yet.
Yeah, I'd say we don't have consensus on B. All right.
Okay. So those are kind of the major issues that have come up with vacation rentals. Do you have more questions about vacation rentals as a whole before we move on to accessory dwelling units? Is there something that we didn't cover that is left out here?
The only thing, this is Tim. The only thing that I think it would be useful to conclude whether we have any interest in pursuing or not, based on the three set. I don't know how you want to count the sets, but based on the comment papers that we received, there were a number of other recommendations for policies that we adopt, and several of those, to me, I would like to see if we can take off the table, because I think they have, well, I don't agree with them, and I think they have significant problems to them. One of those is the continuing recommendation that we require approval by a homeowners association as part of a vacation rental permit. I think that's a very bad policy, because it allows the homeowners association, without any due process to its member, to preclude them from having a vacation permit. It shifts the burden inappropriately, in my mind, from the homeowners association to challenge an owner to the owner, to sue their homeowners association if the homeowners association refuses to write a letter that says it's okay. So to me, the county shouldn't be involved in that, and we should take that off the table, because it's not the county's business, seems to me. That's one. So we can stop hearing about it, or just make it clear that we don't think that's appropriate, is what I think would be useful. Again, to try and focus on what does matter.
I don't have much information.
Okay. And is there a third?
I'm sorry, I was
just wondering, you were responding to two issues that you'd like to take off the table.
Yes. No, the other one was just a gripe about the rhetoric, so we don't have to get into that. That's the one. That's yeah. I don't think that's appropriate. The other one I wanted to point out, we probably ought to perhaps consider, and that is tying the permitted number of renters to the septic permit or the building permit or something, rather than number of bedrooms, just to cut off that argument. And my question there, I do have a question there, and that for Erica or Adam, and that is, would that type of a change dramatically affect your ability to manage the process?
Adam or Erica?
What happened to Adam?
I know we talked about this a few years ago when we updated the rule, but I thought there was some problem from a technical matter if we were to base it on the septic permit or the building permit, which ought to tie, instead of number of bedrooms.
So this is Adam. I won't I wasn't here for the debate at the time that the regulations were adopted, but the number of bedrooms is between the septic permit, what we permit, and a building permit. Those all have to match up. That's something that we review at the time of that we review that vacation rental permit. So we actually, when we're reviewing these permits, we pull the old septic permit and the building permit and make sure that what they're proposing is what was actually permitted in the structure. In terms of the sizing of a septic system and the number of people per bedroom, I think Erica might be able to speak to that better than I can. Yeah.
Yes. Originally, there was we were trying to fix that mismatch between a septic system sizing and the number of guests allowed in a per bedroom or in the vacation rental. And I'd have to go back and say, I believe that the septic systems are all sized for like 2 people per bedroom. And I think originally we were allowing 3 people per bedroom with the original vacation rental rules. What came out of the amendment after having been to council was we are allowing 2 people per bedroom plus 3 additional guests total, or 2 additional guests, something, I can't remember. Sorry, it's late in the afternoon. Anyway, so there still is sort of a mismatch between like the sewage capacity, the way that they plan, or the number of people per bedroom they are thinking when they plan a septic system versus the number of guests allowed in a vacation rental. That mismatch didn't get fixed with the last round. What did get fixed was that we make sure that the number of bedrooms that you are renting, we actually have a building permit, and all of those bedrooms were permitted as bedrooms, and that the number of bedrooms match up to the septic permit for this number of, bedrooms on the septic permit. So but the total overall number of guests, there's still a mismatch between that and the septic, and that was I would say that was council made the final decision on those numbers.
Okay, so that's very helpful, but that still doesn't mean, that doesn't mean that we might not recommend to the county council or recommend to the county council that we adjust that based on the septic capacity.
That's
and
correct.
Cut out the plus, for example. Because that seems to be tied actually to a real live, to a rational identification of an externality, and so I don't imagine that our septic capacity or our water capacities are going to dramatically improve in the near future. So it seems to me that's something that could be addressed or could be thought about as a performance standard, at least as we move forward. So as it turned out, I misspoke. There was one I wanted to put on the table as something we might add back in, since it appears to be rational, and another one that I think is irrational, if not outright wrongful, and that's giving the homeowners association essentially a veto.
Right. So these were not originally part of Adam's briefing today, but I believe we could go ahead and by consensus either affirm that we want to take these off the table or leave them.
The way I understand it, Madam Chair, is that you'd like to, the Planning Commission, if done by consensus, would like to revisit the time of the number of renters to the septic. They would like to revisit that perhaps at a later time and further discussion about this, because as Tim just said, this could be brought up again. And then that they would like to have removed from discussion permit approval by the homeowners associations.
Right.
Yeah, actually, one of those, on the other, I'd just like to, by consensus, to move forward and reevaluate the question that's been asked about the septic system
I like that word. Okay.
Yeah, to re-examine that by consensus, and I'll make a motion actually, just so that it is in the record and people can look at it. But if that's in order, I can make that now.
Yes, please do.
Okay, I move that the Planning Commission confirm the decision that we made in updating at the time that we updated the vacation rental regulations, not to require homeowners association approval or sign off on a vacation rental permit. And I can explain the rationale. Well, if there's a second, I'll explain the rationale.
Go ahead.
Camille seconded.
Okay, the rationale is this. If you adopt the rule that's suggested here, that the county wouldn't issue a vacation rental permit unless the homeowners association signed off on it. It has the adverse effect of getting the county, not only getting the county involved in homeowners association homeowner business, it causes the homeowners association to be able to put their thumb on the scale, if you will, without due process. It shifts the burden of proof. Normally, a homeowners association would have to incur the cost of filing a lawsuit against the homeowner for alleged violations of a CC&R. What this would do is allow the homeowners association, willy-nilly perhaps, but in any event, to shift the burden of proof by just withholding that sign-off, forcing the landowner to sue over the issue. And I think that's way inappropriate for the county to shift that burden and allow neighbors who may or may not have a right to challenge these things to shift the burden to the individual homeowner. I just don't think that's appropriate. If the homeowners think that it's a violation of the CC&Rs to have a vacation rental, then it's well established. They file a lawsuit against the person or threaten to file a lawsuit against the person, and they work it out amongst themselves. But the county shouldn't be in that, because why is the county involved in enforcing a private contract? It doesn't make sense.
Okay. Is there further discussion? If not, call the motion, call the question. All those in favor, I'm sorry, I can't do that. Jim, are you in favor of the motion?
I am in favor of my motion.
I thought you might be. David?
Yeah, I'm in favor.
Neil, Randy?
In favor.
Stephen?
Yes.
I seconded, but I'm in favor as well. Okay, and then.
Thank you. I think that'll be helpful to us.
Okay, and then the other portion, or the other item, was something that we're simply, well.
I'm recommending that we reevaluate the decision we made a couple years ago. I think the county made a couple years ago about in determining the number of allowed renters, to tie it not to bedrooms, but perhaps to tie it to, and I'm not saying how I come out on this, I'm saying reevaluate, tying it to septic permit as opposed to number of bedrooms.
Okay, so by consensus, do we want to move to reevaluate? Tim?
Yes.
David?
Yes, I think we should reevaluate based on the design capacity of the septic system per the county records.
Dale?
Thanks, David. Better put than I had.
Yes to both motions.
And Stephen?
Yes.
Yes. Yes. Okay. Where does that leave us, Adam?
And that was by consensus,
Yes, it
correct?
was.
Okay, just wanted to make sure.
That takes us to accessory dwelling units. So let me get this, share my screen again here.
Madam Chair, I'd like to float the suggestion to see if anybody wants to continue at this point or continue the ADU discussion till next time.
I think we should finish up the ADU unless other people object.
No, that's fine. I just wanted to
Okay.
throw that out there.
All right. Adam?
Okay. Just a moment here. Okay, so next we'll look at the policies and regulations for ADUs. An accessory dwelling unit is a living area that's accessory to a principal residence. And basically they provide, it's a dwelling unit that provides a bedroom, a kitchen, and a bathroom that's separate from that principal residence. They can be either attached, so that would be like if you converted your garage into an apartment and it shares a wall with your house, or they can be detached from the principal residence. That's what we typically think of with an ADU, where it's a completely separate structure. These ADUs are typically brought up because they're potentially affordable housing units. As I mentioned in our last discussion, they're typically smaller dwellings that can be available for long-term rental. And usually because they're smaller, that's at a lower rate than like a larger single-family residence. They're a controversial topic in the county, in rural lands in particular, because they have potential adverse impacts to rural character and might represent an increase in rural density. The GMA does not have any specific requirements for ADUs, but the Act does aim to limit and reduce sprawl in our rural lands, while also encouraging the availability of affordable housing. Those two kind of overarching goals of the Act are can be in conflict together. And in the past, when our ADU code was appealed in the early 2000s, the folks that appealed cited the reduction of sprawl and preserving rural character as kind of the primary issues of why they appealed our old code. And that appeal led directly to our current ADU regulations, which were adopted in 2007. As I mentioned, they were concerned, the appellants of our old ADU code were concerned that by not setting a limit to the number allowed, the county was allowing inappropriate rural density by effectively doubling density in our rural lands. And this was seen as having a negative impact on our rural character by allowing that more intense built environment in those rural lands that we've kind of set aside for less intense development. The hearings board agreed with the appellants and remanded those regulations back to the county. And now our ADU regulations limit the number of ADUs, the number of permits that we can issue per year. And that's why we now have a lottery system that we can only issue 12% of the building permits from the previous year. That's the number that we can issue for detached ADUs in the next year. So we can look at ways to maybe modify the ADU limit, but we need to take care to make sure that we're not jeopardizing rural character or kind of running afoul of what in the ways that we did in the previous code. So the ADU code really seeks to address the impacts to rural character with very specific design standards. I have here on the slide a site plan from a recent ADU permit that was permitted in 2019. And it shows some of these requirements that are aimed at kind of addressing this rural character impact. So to start with, the ADU cannot exceed 1,000 square feet. This gray structure on the site plan here on the right is less than 1,000 square feet. It's at about 500 square feet. And then if we look at one of the other requirements, you can't see it on a site plan, but the ADU and the principal residence must be owned by the same person or entity, and they must share a driveway and utilities. So we can see on the site plan here, the ADU and the principal residence, zoom out again. The ADU and the principal residence both share a driveway, This dash line with the S is their septic system. They're both connected to the same septic system. See here, another requirement is that the ADU cannot be more than 100 feet from the principal residence. We see here that this example is about 70 feet from the principal residence. And then we also have a minimum lot size for detached ADU. They're not allowed on parcels less than 5 acres in any rural designation, 10 acres in any agricultural resource land designation, and 20 acres in forest resource land. This example site plan is from a 12-acre parcel in rural farm forest in a rural land use designation. So there's 2 primary issues around ADUs that have come up recently. First, we can consider allowing ADUs without the lottery, provided that they are permanently restricted to affordable housing. So we can look at maybe allowing more, provided that they're restricted. Second, we received an annual docket request in 2019 to allow the separate sale of accessory dwelling units and principal residences, provided that underlying land remains in the same ownership. The council decided that the county would consider this docket request during the plan update. So that's how that ended up on our plate here today. The first issue on whether to allow ADUs not subject to the lottery, provided they are required to be affordable housing. This is one of the strategies identified in the county's 2018 Affordable Housing Work Group Strategic Action Plan. The primary challenge is that ADUs contribute to the achieved density in our rural areas, but they also might provide some affordable housing. So the county can look at possibly reducing this limit that we've established on the total number of ADUs, provided they meet some of these affordability requirements in the county code. And this is really frequently brought up in public comments as one area that could increase the supply of affordable units. Some of the benefits of allowing more ADUs, if they're required to be affordable, are that the property owners would have more options for developing affordable housing. More affordable rental units could be provided in those rural areas. It would allow affordable housing options beyond multifamily housing, and it enables people from more diverse income brackets to afford to live in rural areas. Some of the drawbacks of allowing more ADUs, provided they're affordable, is that it could increase demand for rural infrastructure, such as like roads and water. It would lead to a higher achieved density on lots developed with both a single family residence and an ADU. So there'd be more dwelling units per acre. But also lower income households may have trouble accessing services that are only available in the UGAs. So one of the benefits of having affordable housing in the UGAs is that they're closer to some of the services that folks need. And then furthermore, the only guarantee that we would have is that if the owner decided to rent the unit, then it must be affordably priced. So those affordability requirements don't necessarily affect the ADU if the property owner decides to just use it as an ADU and not rent it out. And then finally, this could also lead to another appeal of the ADU code, kind of on the same grounds that people would be concerned about impacts to rural character. And so here we have kind of the option is to maybe allow more ADUs, provided they're restricted to be permanently affordable, or we don't have to make a change. We can keep the limit in place for ADUs in rural lands.
Adam, I have a question. Do we have any information as to, the demand for this option of using ADUs to provide affordable housing? I mean, do we have any information that this actually could have make an effect? Actually would provide more affordable housing other than just theoretically?
I don't have a quantified answer to that. I can say that when we did the community workshops, both for the vision in 2017 and then our comp plan update workshops in 2018, at both of those and in our public comments since too, many people when talking about affordable housing, this is like the first thing that comes up, suggesting that there's probably a fair amount of people that are interested in developing an ADU for some kind of affordable housing, but I can't tell you the number of them. Just that it is something that we hear frequently.
Could I ask a question about that? Go ahead. Sorry.
Oh yeah, I think David, I got there a little bit for you. So it looks to me like we only had 13 applicants for ADUs this year, and only 6 winners. So it seems like, I know in past years I've applied for this myself, but typically there's a pretty good matchup between the 12 permits that are usually allowed or thereabouts and the number of applicants. Is that true? And it makes me wonder if we need to, if this is necessary at all, given that we have less applicants than slots right now.
So we definitely had, this year we had more people apply for ADUs. We had to hold a lottery drawing this year for ADUs, and typically we do. So in the last couple of years, I've been in charge of that program, and every year we have more applicants than we have spots available. I
Looks
think
like 13 this year. Oh, I'm looking at the drawing results, and only 6 winners, though. I don't understand why. Maybe only 6 qualified applicants?
no, there were only 6 spots available. That's how
Oh, there were.
limited the number
Oh,
is.
okay. Shoot, my bad. All right.
Yeah. No, it's okay, but I think
When I applied, I think there was 12.
yeah. Yeah,
Gentlemen,
so-
please try and not speak over the top of each other. Thank you.
Okay. So I will say that it's kind of hard to, because it's fairly well known that the county does not limits ADUs. I think that has a cooling effect on how many people are willing to apply. And I don't think we've never had a system where you would allow them, but they would have to be permanently restricted for affordability. So it's, I couldn't say with any confidence what effect that might have on the number of applicants we would receive or how many people would be interested in developing. But I do know that when you're the person that answers the ADU questions, you get a lot of phone calls. And so like there are definitely people that are interested in developing ADUs out there. I just don't know how many of them would do it for affordable housing.
Right.
One
This is
follow-up question.
Oh, go ahead.
I just wonder, I think I like the idea, but I would maybe like it on a trial basis or restricted to, 6 additional, 10 additional ADU permits. I just don't want this thing to go, unrestricted growth of ADUs is kind of scary to me.
Yeah. Well, and sorry, this is Adam again in response. I think, we could look at in kind of refining the proposal as we get kind of further down the road on this, we could look at setting a specific limit or maybe trying it as a pilot program for a couple of years to see what kind of interest there really is for it. But with a very restricted number of, we're going to allow 6 or whatever, whatever the number is as a trial run before going full blast. That is an option that would be available as we kind of work to refine the proposal.
There was somebody else that was to comment.
Yeah, this is Tim. What I was, and it worked out. The sequencing worked out perfect to that, because notwithstanding the very recent experience for many years, a lottery wasn't required because it was always undersubscribed, and the reason it was undersubscribed is that it wasn't there was no permanent affordability criterion, but people had difficulty satisfying the other requirements. And so I really wonder how much effect this will have if all we've removed is the lottery, because for years prior to this most recent experience, we didn't have folks applying for the lottery because they couldn't meet the other performance standards. Either their lot was too steep to make the same driveway work, or they had other issues that precluded qualification. So I'm not suggesting that we relax those other qualifications. On the other hand, the other comment I wanted to make was I think there's the statement I wanted to raise a statement in page 4 of the staff report. It says the problem is that simply adding more ADUs will not satisfy the GMA mandate to reduce sprawl discussed above. The problem with that is that's, to my way of thinking, that is spin, because the original allegation that that ADUs had an adverse impact on rural character was a conclusion the county council reached, which was entirely inconsistent with the vast majority of the testimony that was presented at the hearing. That testimony made very clear that having of ADUs was actually part of the rural character and entirely consistent with the character of the island's rural communities for years and years, and that's still true. Yet, to avoid or to address what was alleged to have been double density and causing of sprawl, which I'm still baffled how having a house, having an ADU within 100 feet of your house contributes to sprawl at all. It's not a separate homestead. It's on the homestead. So I just challenged that statement. I challenged the conclusion that the court would reach the same thing. In fact, my firm belief is that since San Juan County did appeal that growth board decision to the Court of Appeals and briefed in the Court of Appeals, and I reviewed that stuff. It was part of my first contact with the county. I firmly believe that San Juan County was about to win its appeal and not have to adopt the current guest house ordinance that we have, but for a change in the composition of the county council. So I do not believe it's accurate to conclude that the law in the state of Washington requires that. It requires it in this case because San Juan County withdrew its appeal because of a change in the county council composition. So stating it as a fact that the GMA requires what we have now is not, I don't believe is accurate.
Erica would like to respond to that, Tim.
Please.
This is Erica, and I would agree because other counties do not have this restriction that are also GMA counties. So I do not believe that GMA says that you cannot have accessory dwelling units with in the rural areas.
So that's I think that we should be reevaluating the current rule anyway because of its potential impact on folks who are here. Now, whether we want them to be vacation rentals is a different question altogether. But whether people should be allowed to have one to accommodate their guests or to accommodate caregivers, or to be a fair market value rental of 1,000 square foot right in somebody else's backyard, that's not been tested in San Juan County because we have this rule. So we don't know whether that would help alleviate part of the problem if folks were allowed to do it without a permanent, affordable solution. So I just raised that point. One, I don't think that this necessarily gets the job done because most of the limitations are in the performance standards in any event. And second, I personally won't be for it because I don't think it's a fair land use restriction. But I just wanted to get that out there. Most important, I don't think the statement in the staff report is objectively accurate.
So would you propose language that would cause us to reevaluate or ask council to reevaluate the language in the GMA?
Yeah, I mean, first off, as I say, the prosecuting attorney's office took that appeal, so it has a very good idea of what it believes would have happened at the Court of Appeals. One, the county doesn't have to rely on me. The prosecuting attorney's office had direction from the county council to several times delay the issuance of a decision while the current guest house ordinance was worked, while the local solution represented by the current guest house ordinance was enacted, and then ultimately to withdraw the appeal. So I guess the question is, I mean, I certainly can make a motion. I'm wondering whether we have consensus, though, to reevaluate whether eliminating the lottery as part of the comp plan update makes sense, because it would allow people additional options, would be consistent with rural character, and because I firmly believe that the current rule is not. For a variety of reasons, and I can certainly argue those, but I hadn't really wanted to make the argument unless we thought it was worth deciding. But I think it's not hard to find the elements of the vision that are supported by the ability to have a guest house, that is dramatically undermined by the ability not to. And I can provide hypotheticals that aren't so hypothetical as well. So,
consensus
to reevaluate that. Now, I don't know how much appetite there'll be, because there is a contingency who thinks this is one of the things that will solve our affordable housing issue. Whereas, as noted earlier in the discussion, you're talking about 1,000 square feet. You're talking about 1,000 square feet that shares a driveway with somebody else, and 1,000 square feet that is too many, would have a lower market value because of, to some extent, compromised privacy, right? Because you're within 100 feet of your landlord.
Exactly. Okay, Erica, did you have something further you want to point out?
Yes, if I may. Part of the reason we understand that accessory dwelling units are a very controversial topic. And there isn't, I would say there's probably not a lot of appetite to make changes to it, just because of probably the time and expense related to litigation. And, in all fairness, I can't, recommend that we go out and start, working on something. But it is an issue. It is an issue that we heard again and again and again when we went out for public comments. And then also the affordable housing group, who actually they didn't suggest that we don't have a lottery for ADUs. They suggested we figure out how to relax the ADU rules. And so some of the issues they had, part of it could have been the lottery, part of it could have been how close ADUs are and sharing the driveway and those types of things. So we had these, and then of course we had a docket request. So that's why we brought it forward for discussion, but it is really a difficult subject because of the history of it. I just wanted to let you know that. So.
Well, I don't dispute that, but as you noted, I think it is interesting that it's been imposed in San Juan County because the county imposed it on itself. And people continue to say it's a GMA requirement, but I believe that's not true, and that it is inconsistent with a lot of the values that are reflected in the vision statement, in particular independence, privacy, tolerance, ability for neighborliness, self-sufficiency, all those things that we say we value. Then we just eliminate a major way for people to be independent, self-reliance, and those sorts of issues. Whereas it really doesn't create double density in most cases anyway, at least not that I'm aware of. It's available for folks to use from time to time, and is available for folks it's a safety valve in a lot of cases for folks who have a problem with whatever their current residence is, be it a domestic dispute or an illness or breakup of a relationship or whatever, I've heard story upon story where folks have gone to live in someone's guest house temporarily, whereas otherwise they'd have had to leave the county or have a short-term rental, for gosh sake. And how would you get one of those? So
If there's
if there's no appetite for the county council, that's fine. I didn't submit a docket request or anything like that to bring the issue forward, but I thought I would raise it.
Okay.
This is Dale. Tim, your point was to have it revisited, and given everything you and staff have brought up here in response to your point, why not revisit it? I think these are the kind of things that if we can clear up history or try to, I think we're well served just doing that. It would help all of us, including me, who did not have the benefit of that history and understanding where we are today. So that's where I would should we say, raise my hand should this issue come to consensus.
Well, I was hopeful we'd have a consensus because we'd have the added benefit of having a current process and a current view at the issues. So those who might grumble on either side would have the opportunity to know that there was a process, and we could see what people came forward and said. I know what they said in the past. That might not still be true, and on both sides of that issue. I don't know for sure.
Okay. So do we need to restate the?
Restate. You hadn't finished going through the rest of the planning commission to see if there was consensus.
No. That was the next step. I was just trying to see what it was I was asking for consensus on.
What I would say is, I would restate it as to say, what I'm requesting is that we reevaluate the current ADU ordinance, including performance standards and the lottery restriction.
Okay, and that's your motion, David.
By consensus.
I'll make it as a motion. That's fine. That'll work.
All right, let's have a motion. You made.
I moved it. I moved it as part of the comprehensive plan update process. The planning commission review and reevaluate the current guest house ordinance, conditions of performance standards, and lottery requirement.
Dale seconds it.
Very good. So the motion has been moved and seconded. Is there further discussion? If not, we'll move to the question. So, Tim, I assume you're in favor of your motion.
I am.
Neil?
Yes.
I'm sorry, I'm out of order. David?
Yeah, David's in favor.
Okay, Dale?
Yes.
Steve?
Steve, no.
Camille?
Motion passed.
Okay, the motion passed.
Okie dokie. Adam, I realized that was in the middle of where you were, but sorry about how that came up.
Well,
I
that's
just
much.
I just
more-
realized that I did that. So that was I had intended to raise that, but I didn't intend to put it between your issues 1 and 2. So.
Okay, well, so I guess really I think that really does address issue 1 because you want to take a look at that lottery, and this could be part of that, and then but that's part of a bigger topic. And then as we move forward and look at the performance standards as part of that kind of overall look, we should keep in mind this docket request that we received in 2019 from Opal. So they requested that the performance standards be amended to allow an ADU to be sold separately from a principal residence provided that the underlying land remains in the same ownership. So Opal is a community land trust where they typically sell improvements without the underlying land. And that's the way that they reduce the sale price for their housing. Some of the benefits of removing this requirement are that it would allow more flexibility for these public agencies and nonprofit affordable housing developers to build and sell ADUs, and ultimately that would increase the number of affordable units. Some of the drawbacks are that this would that changing this ownership requirement is essentially just allowing a second, albeit smaller, home to be constructed. And this could potentially have some problems with density. Again, I guess that's a philosophical statement that we can evaluate more now that we've got some more information of where you guys are at. I will say Lisa Byers commented, she's the executive director of Opal, to clarify a few things about their requirement or their requests. They wanted to specify that this would be only inside the urban growth area. And they cited a couple of situations where they were interested in developing an ADU, but because of the subdivision requirements because of the CC&Rs of some subdivisions, they were unable to basically create a second lot where they would have two houses to sell. So this was their way to kind of get around that. So the idea here is that they would have a deed restriction or a lease on the land to provide that affordable housing, perpetual affordable housing in both the primary residence and the ADU. And I believe we forwarded that comment to you guys. So looking at this, kind of the two options here are to amend the code as proposed in the docket request, or to make no change. Initially, we were recommending option B because allowing the separate sale of an ADU and a principal residence would really make those ADUs not function as an accessory dwelling unit. And they would really become kind of a principal residence. So a lot of those factors that Tim illustrated about ADUs, where they're kind of this not necessarily a separate dwelling unit, that would kind of go out the window if they could be in separate ownership, I think. And if we look at possibly, if we want to find ways to get more affordable housing, I think we can address that through other policy choices other than this specific allowing separate sale of ADUs in principal residences. So here I would turn it over to the Planning Commission to discuss.
Okay. Additional comment, David?
Well, I certainly support the work of Opal. However, I feel like this is too much of a one-off for the code amendment. That's my thought.
Okay. Dale?
Yeah, I'm concerned that that the change would not be helpful to the cause. Although I understand that Opal would actually see this as an assist to themselves, I'd have to agree with the staff recommendation.
Looking for its unmute button. Well, I'll circle back. Tim?
Yeah, I think option B is the correct approach, because otherwise I think we lose the whole definitional concept of an auxiliary unit.
Okay. Are you with us?
Are you trying to get hold of me, Steve? I didn't hear you.
Unmuted
Yeah.
in here.
Did you hear what the question was?
Yeah, no, I think no change. I support no change.
I think there are 5 of us supporting no change. Adam, have dealt with policy options today?
Yes, that is the extent of what we had ready for land use issues. I guess now it would be, we did have one more presentation on natural resource lands on the agenda, but we're getting pretty close to 4 o'clock. I don't know if you want to continue, or we can do this next month too. We could plan on natural resource lands next month.
Well, I'll pull the mission, but I suspect that the appetite for a further presentation is small. Tim?
I think we've worked very hard and should come fresh to the next briefing.
David?
Agreed.
Dale?
Agree.
Stephen?
Yeah, I agree.
The chair agrees. So, we'll have a motion to adjourn.
Anybody?
Oh, come on, someone else formulate that one.
Just a minute. I have a,
Camille moved. We just need a second.
this is Steve. I'll second it. But
Perfect.
Afterwards, I have a comment to Linda. Okay.
Okay, just one
About attendance at the next meeting.
Oh, then let's not, let's have discussion about your motion. How about that? Okay, you guys are laughing at me now. All right, Steve, go ahead and tell me what your problem is about attendance.
Oh, I'm not sure I just wanted to inform you, I may not be able to be available next month.
Thank you for that. I appreciate it.
Okay.
Anybody else already know? Okay, thank you. So now we can go ahead and see if this motion to adjourn passed.
Yeah.
Okay, you're off the hook. Everybody can shut down and have a really good weekend. Till next one.
You too.
Thank you.
All right.
Everyone take care.
Thank you.
All right. Goodbye, everybody.
Bye.